Good morning, everyone. Welcome to Law Excellences Initiative Current Affairs for Beginners. Let us start our today's session. Before starting our today's session, let us see what are the answers for the questions from our yesterday's video. Consider the following statements. At the national level, the Ministry of Home Affairs is the nodal ministry for all the matters concerning disaster management. Yes, it is the Ministry of Home Affairs who is the nodal ministry for disaster management. The second statement is disaster management is the subject under concurrent list. This statement is wrong because disaster management will not fall in any of the three lists. So it is the parliament who will legislate on the subject. But the primary responsibility for managing the disaster is with the state government. Here the central government will legislate and the state government is the one who will implement who will manage these disasters. So as the statement 2 is wrong and 1 is only correct, the answer here is A, 1 only. The next question is, which of the following constitutional articles have a bearing on health? Article 38, 39E, 41, 42, 47 and 48A. All these articles were having a bearing on health. So the answer here is all the above, D. Now let's start our today's session. Our first article is Center wants Supreme Court to get tough with Facebook, YouTube. In an attempt to curb the menace of the circulation of these online videos that were related to sexual violence and sex against women and children, the government is seeking the help of Supreme Court in order to give strict directions to the online service providers like Facebook, YouTube, WhatsApp, all this. Here, the government has suggested some directions like to the service providers like fast track. Here, previously the government has given this time for service providers to remove the content from their websites within 36 hours. When a request was made to the service providers, then any content that is related to sexual violence against women and children, the service provider should remove it within 36 hours. But now, the government want to reduce this time period to 10 hours. The next one is spot and kill. The center is saying that the service providers should find out and they should remove this content, especially those that were related to child pornography and rape. And the next one is tracing the roots. The center is telling the online service providers are responsible to identify even the origin of such content. That means who is posting this kind of content. The next article is the worst floods in a century. Kerala tells the Supreme Court. From this article, now we will see what is this National Disaster Response Force. This National Disaster Response Force is the India's elite disaster mitigation combat force that was established in 2006 under the Disaster Management Act of 2005. This Disaster Management Act of 2005 has created two authorities like National Disaster Management Authority as well as this NDRF, National Disaster Response Force. This National Disaster Management Authority will lay down the policies, plans and guidelines for disaster management. Whereas this National Disaster Response Force, from the name itself indicates, it is mandated to undertake specialized disaster responses, relief, rescue operations and combat roles independently in case of any event of disaster that can be either natural or man-made disaster or an accident or emergency. This NDRF will also assist the local authorities for quick rescue and response operations in order to save life and property. At present, the NDRF has 12 battalions, out of which 3 are from Border Security Force, 3 from Central Reserve Police Force, 2 from Central Industrial Security Force and 2 from Indo-Tibetan Border Police and 2 from Sashastra Seema Bal. All these were responsible for providing aid and assistance to the affected states. As I have said this, NDMA is the authority to lay down the principles and guidelines regarding the disaster management. It is the apex body for disaster management in India, and it is chaired by the Prime Minister. And the nodal ministry in the central government for management of natural disasters is the Ministry of Home Affairs, and this NDRF comes under the Ministry of Home Affairs. Here, the Home Ministry will have the responsibility to control funds and executing the plans, whereas the NDMA will have the administrative control. The NDRF doesn't have its own air wing. It is not having its own air wing, so in case of any disaster, it can call upon the Indian Air Force for assistance. Our next article is Get Over the Superpower Syndrome. From this article, here there is a mention of Australia Group, Wassenaar Arrangement and Missile Technology Regime, and Nuclear Suppliers Group, Asia Pacific Economic Cooperation. Now we'll see all these in detail. The first one is Australia Group. Australia Group is a multilateral export control regime. It is an informal group that works to control the spread of materials, equipment and technology that will contribute to develop the chemical and biological weapons by the states or terrorists. This is an export control regime group of these materials, equipment and technology that can develop these chemical and biological weapons by the states or terrorist group. And at present it has 43 members and India is a member of this group. Whereas Wassenaar Agreement is also an informal grouping of 42 countries, and recently India has joined this grouping. This grouping is formed to control the export of dual use goods and technologies. This Wassenaar Agreement is an multilateral export control regime that is formed to control the exports for these conventional arms and dual use goods and technologies. Whereas this MTCR, the Missile Technology Control Regime, is also an informal and voluntary partnership among the countries to regulate trade in sensitive equipment and technology in order to ensure that there is no proliferation of missile and unmanned aerial vehicle technology that is capable of carrying payloads above 500 kgs for more than a range of 300 kilometers. That means here it wants to control the proliferation of missile and unmanned aerial vehicle technologies which can carry payloads above 500 kgs to a range of 300 kilometers, and India has joined this MTCR in 2016. Whereas the Nuclear Suppliers Group is also an export control group. This group is formed to control the exports of sensitive nuclear technologies and the equipment in order to control or to prevent the nuclear weapons, the proliferation of nuclear weapons. And NSG is the only export control group in which India is not a part of. India is a member of Australia Group, Wassenaar Arrangement, MTCR, whereas India is not part of this Nuclear Suppliers Group. And the next one is Asia Pacific Economic Cooperation. This is a regional economic forum of 21 Pacific Rim countries. And these Pacific Rim member economies was formed to promote free trade area throughout the Asia Pacific region. And these 21 member countries, they together account for nearly 50% of the world's trade and 57% of world's GDP. India is an observer of this APEC, Asia Pacific Economic Cooperation, and it has applied for membership in 2011. That means India is not a member of this APEC grouping yet. Our next article is, should Article 35A be scrapped? What is this Article 35A? We have seen this so many times, but now again we'll see it in brief. This Article 35A in the Constitution is related to the state of Jammu and Kashmir. Article 370 of the Constitution has provided special status to Jammu and Kashmir. And the presidential order that was issued in 1954 under the Article 370 has also added Article 35A to the Constitution by giving powers to the state legislature, that is Jammu and Kashmir, to define permanent residents of the state as well as their privileges. This article was added by the presidential order but not by amending the Constitution as per Article 368. And according to the Jammu and Kashmir's Constitution, a permanent resident is a person who belongs to the state on May 14, 1954, or a person who is resident of Jammu and Kashmir for 10 years and he should have acquired legally immovable property. That means a lawful property in the state. And persons other than the permanent residents in the state were considered as secondary citizens. And these non-permanent residents are barred from settling in the state and acquiring immovable properties, seeking employment, or to do any trade or business. And these non-permanent residents, they cannot even approach the court. They can't seek any redress from the court based on these provisions. And this article also denies property rights, inheritance of property rights to a woman if she marries a non-permanent resident, and also her children cannot acquire the rights. Here from this article we can see here. Here it treats the non-permanent residents of Jammu and Kashmir as second-class citizens, and these people were not eligible for employment under the state government and are debarred from contesting elections. Even the students can't get scholarship and they can't seek any redress in any court of law. The major sufferers are women who marry outside the Jammu and Kashmir. The women who belong to Jammu and Kashmir, they will remain as permanent residents, but their children cannot become permanent residents. Our next article is another step in the battle against leprosy. According to the previous personal laws like Hindu Adoptions and Maintenance Act, a Hindu wife can stay separately from her husband who is suffering with leprosy, and she can also claim for alimony, that means maintenance charges from her husband who is suffering with leprosy. Now this provision of stating leprosy as a ground for dissolving the marriage or divorce is removed from the Personal Laws Bill, Amendment Bill of 2018. This is done in order to integrate the leprosy patients into the mainstream and to remove the stigma that is attached to this leprosy patients, because now there were modern medicines that were available to completely cure the leprosy. And the United Nations General Assembly has drawn a resolution to eliminate the discrimination against the persons affected by leprosy and their family members. And India has ratified this resolution. This is one reason, and even the National Human Rights Commission has recommended to introduce a law that will amend the personal laws. And the Rajya Sabha committee as well as the Law Commission of India, they both have recommended all the related ministries and the state governments to remove any provision that is related to discrimination of leprosy affected persons from the laws. Our next article is EPFO data not the right gauge of employment level. What is this EPFO? Employee Provident Fund Organization. This Employee Provident Fund Organization is a statutory body under the government, and it functions under the Ministry of Labour and Employment. This statutory body was formed by Employees Provident Fund and Miscellaneous Provisions Act of 1952 in order to administer three schemes like a compulsory provident fund scheme, pension scheme, and an insurance scheme for the workforce that were engaged in organized sector in India. This EPFO will help, or it will assist the central board in administering all these three schemes. And these schemes cover Indian workers as well as international workers. International in the sense it includes the workers in the countries with which India has signed bilateral agreement related to social security. So this EPFO is also a nodal agency for implementing these bilateral social security agreements with other countries. And based on the number of beneficiaries that were covered under these schemes and the volume of financial transactions, based on these two aspects, this EPFO is one of the largest social security organization in India. And the decision making body in this organization, that is EPFO's decision making body, is Central Board of Trustees. It is the decision making body in Employees Provident Fund Organization. Our next article is National Company Law Tribunal may receive new cases worth 70,000 crore. What is this National Company Law Tribunal? This National Company Law Tribunal is a quasi-judicial body that is entrusted to adjudicate or to govern the cases that were related to companies in India. This National Company Law Tribunal is established under Companies Act of 2013 and it is a successor body of Company Law Board. And when it comes to the powers that were given to this National Company Law Tribunal, it will have the same powers that were assigned to this Company Law Board, as well as it will have powers to hear the cases that were pending with Board for Industrial and Financial Resolution that deals with the revival of sick companies, and it has powers to adjudicate all the proceedings that were pending before any district court or a high court. And even the recent Insolvency and Bankruptcy Code of 2016 has also given various powers to this National Company Law Tribunal to adjudicate, that means to govern upon the insolvency resolution process and to liquidate a corporate debtor. Our next article is NSE seeks comment on GDP back series. What is this NSE? National Statistical Commission. This National Statistical Commission of India is an autonomous body that was formed in 2005. Various statistical agencies in India like the Central Statistical Office and the National Sample Survey Organization, they face lots of problems while collecting data from the state as well as central government departments. So, in order to reduce these problems that were faced by these statistical organizations like CSO and National Sample Survey Organization, this National Statistical Commission was established in 2005, and this was established based on the recommendations of C. Rangarajan Commission, which is also called as C. Rangarajan Economic Advisory Council. This was done in order to enhance public trust in the statistics of India. That is how the data is being collected from state and central governments. Whereas this National Statistical Commission will emphasize on ensuring the collection, that means ensuring that data will be collected unbiased. That means without any bias, it will collect the data so that it will enhance the public trust. As I've said before, to enhance the public trust on the figures that were released by the government. That means the statistical information of the government. Now let's see our today's questions. Consider the following statements. NDMA is the apex body for disaster management in India. The nodal ministry in the central government for management of natural disasters is the Ministry of External Affairs. The next question is, in which of the following export control groups India is not part of? Australia Group, MTCR, Wassenaar Agreement and Nuclear Suppliers Group. Try to answer these questions and post the answers in the comment box. The detailed explanation for these questions will be seen in the next video. This is our Law Excellence website where you can access notes for this video, and this is our official Telegram channel for Law Excellence. Thank you.